All right, well, my clock shows almost 12:02, so we're going to kick this off out of interest and respect of all of your time. Good afternoon, and thank you for joining us for today's CLE focused on how best to respond to DOJ demands in the healthcare industry. My name is Jason Castor, and I'm the Chief Business Development Officer for Parsons, Bailey & Latimer, and I'd like to welcome you to today's CLE. We had a fantastic response with more than 120 registrants. And while I wish we were able to conduct this webinar in person and provide you with a box lunch, given the current environment, this will have to do. But thanks again to all of you for taking the time out of your busy schedules to join us today virtually. I'd also like to extend a thanks to the criminal law, health law, and litigation sections of the Utah State Bar and the health law section of the Idaho State Bar for their partnership and support of today's event. Before I turn the time over to our fantastic presenters, I'd like to cover just a couple of quick logistical items with all of you today. First of all, today's CLE is being recorded, and you will be provided a link to the recording within 24 hours so that you can share this with your colleagues and teams that weren't able to participate. Second, we'd like today's webinar to be as interactive as possible. So please feel free to submit questions using the chat feature throughout our discussion today. You can submit those directly to me or to either Mike or Jeff. And finally, for the purposes of CLE credit, you will receive an email from us tomorrow requesting your bar numbers. So please provide us with this information and we'll submit CLE credit on your behalf. The email that you're going to receive from us tomorrow will also include a copy of today's slide deck, and a link to the recording of today's presentation. So with that, I'd now like to turn the time over to my colleagues, Jeff Corey and Mike Young. Gentlemen, the floor is yours.
All right. Hey, thank you, Jason. Before we get too deep, I just want to make sure, Jason, Corey, can you hear me okay?
Can hear you just fine, Mike.
Okay, perfect. Thanks for that introduction, Jason. I want to just echo before we get going, Jason's sentiments that to the extent you have questions as we go, please feel free to put those into the chat feature. You know, as a part of this new pandemic world, we're all adjusting. Putting on a CLE like this is not ideal, and typically I would want people in the room with me so I could see them laughing at my jokes to help build my confidence. I'm just going to assume that you're laughing at my jokes and that things are going well. But in all honesty, as we go, we're going to be covering certain topics, and a lot of times it's just easier to address questions as we're working through the material. I think it also makes for a much better presentation. Before we get started, though, I do want to sort of give you a little bit of information on my background, how I've come to be here presenting to all of you, and then give Jeff the same opportunity. My first interactions with, I guess, what I'll call this area of law, which we'll call the False Claims Act, Anti-Kickback, and then as well as whistleblower litigation, came on the plaintiff side, where we had brought a key tam lawsuit on behalf of plaintiffs in a medical device case. Following that, I've been since retained by other device manufacturers in both False Claims Act and Anti-Kickback litigation, pharmacies, assisted living centers, hospices, and most recently representing certain insurers, health insurers, before the Office of Inspector General on sort of more administrative matters, dealing with, while not necessarily False Claims Act and Anti-Kickback litigation, but dealing with medical billing and coding issues, which seem to always be an integral part of a lot of these cases. And so that's the perspective that I bring to the table. Jeff, I think, brings a different perspective, and I'll let him expand on that.
Yeah, thanks, Mike, and thanks everyone for being here. Where I come into these cases is from the defense side. Before joining Parsons, I was an assistant federal public defender where I did exclusively federal criminal work. both white collar and blue collar. And for the past 7+ years at Parsons, I have been focused on regulatory enforcement matters, healthcare, SEC, EPA, anything involving sort of regulatory investigations, which has included a number of kickback and FC, False Claims Act related cases. And so, with that background, Mike and I, have both plaintiff side and defense side experience here that we think is really relevant. We've also both worked on a number of FCA cases, and we thought it would be helpful to really give you kind of a practical nuts and bolts perspective on how to deal with civil investigative demands. We approach this from our experience. We don't profess to be have all the answers. That's why we hope we get some participation and learn from each other. We're going to share with you some things that we've seen in cases that have worked and not worked for us. And with that background, I think we want to start with the legal background before we sort of get into some of the practicalities of responding to a CID. We want to spend a few minutes talking about the False Claims Act, the Anti-Kickback Statute, and specifically the CID statute. So with Mike, I'll let you begin with that part.
Yeah, thanks, Jeff. So, as we were sort of putting this presentation together and looking at some of the people that were attending, Jeff and I both sort of remarked that there are a number of people in this virtual room that have relevant experience and insight, and that we were excited to see participating and would encourage further participation. In putting together the program today, one of the things that really struck me was sort of how intertwined not only the underlying statutes are, but how many different actors can get involved in these kind of cases. So you have sort of Main Justice can get involved, the Office of Inspector General can get involved, local U.S. attorneys' offices can get involved, relators or, the individual attorneys general, as the statute calls them, can get involved. And so almost immediately there are a ton of moving parts to consider, and there's probably more rabbit holes to go down than makes sense today. But just as an initial observation, I think it's really critical to sort of consider that at whatever point, whether you're a corporation acting in the healthcare space, or perhaps you're a corporation, that works in the procurement space or something else, and you get involved or somehow you're served a CID, the reality is receiving a civil investigative demand could mean almost one of a million things when you start to consider all of the actors and all the backgrounds that go into this. And so quickly I want to run through just some of the legal standards, and we'll start with the False Claims Act. And I know that most on the call today probably have some familiarity with the Act, so I won't spend a ton of time on the law. But for those familiar, the False Claims Act sort of has this section 3729A1, and under A1 there's kind of a list which really reads like a list of theories of liability that a company or individual may find themselves exposed to potential damages under the statute. And the most important, or the easiest way I think to distill that down, is any corporation or individual who causes or presents false or fraudulent claims to the government, and you can do that either directly, as listed under Bullet 1. You can do that by providing supporting statements that would validate or to support a fraudulent claim, or through a third party work to secure payments that the Act outlines as false or fraudulent. The upside, as we're all familiar for doing so under the False Claims Act, is the liability for a civil penalty, which is outlined below. I think the most recent release of those penalties was in June 19, 2020. which provides for a penalty of $11,000 to $23,000 per instance. And of course, as we all know, those penalties then can be trebled at the discretion of the court. And so where we see it, the reason that I think we see the healthcare industry targeted so heavily, especially recently, is with the sort of the involvement of, or what we've seen, the influx of use of Medicaid and Medicare funds for payment of medical bills. As the baby boomers are aging, you see Medicaid being used much more, and through the expansion of Medicare through the Affordable Care Act, you're seeing more Medicare monies being used. The bottom line is the more that we see healthcare monies being spent by the federal government, the more exposure that's going to be out there for the False Claims Act. Again, to continue on the relevant legal standards, I'm not going to go into detail here other than to highlight the one definition. We often refer this as permissive intent requirement. Under the knowingly, actual knowledge, deliberate ignorance, or reckless disregard all qualify for the knowingly requirement under the statute, meaning that specific or direct intent is not required. We see cases, and Jeff's going to talk about some examples later, but there are certainly instances where corporations, although maybe not directly intending to defraud the government, sloppy or I guess reckless advancements of payments or claims for reimbursements certainly would qualify under the standard. And that's something that's a gray area that you'll see gets highlighted as we move further down into some of the standards we're going to discuss. The upside of all this, in 2019, under the False Claims Act alone, the DOJ recovered more than $3 billion in settlements, and of that $3 billion in settlements, 2.6 related to the healthcare industry. We've seen over the last 5 to 10, but certainly over the last 3 to 5 years, a really sort of a hyper focus from the government on the healthcare industry and the False Claims Act itself. And with that, I'll turn it over to Jeff to talk kickbacks.
Yeah. And so this is the other side of the coin here in terms of healthcare and the key statutes. Want to focus here on the Anti-Kickback Statute. Again, I want to acknowledge that some of you on the call have already dealt with this statute a lot. You probably know the basic elements if you're interested in this topic, but we've quoted here the kind of the key language. Just for context, it is the Anti-Kickback Statute is the primary federal law that prohibits bribes, remuneration, anything intended to induce referrals or reimbursement under federal health care programs, most often Medicare, Medicaid. It is really the primary anti-corruption statute that the federal government uses to enforce corruption in the healthcare context. From a defense perspective, the tricky thing about the statute is it's incredibly broad. It doesn't apply just to physicians and not just to some healthcare providers. Really, anyone engaging in the healthcare sector needs to be worried about the statute and the reach of the statute. Whether you're providing services, receiving services, goods, we'll talk about some specific cases in a minute, but it is a very broad statute, and what is interesting from a legal perspective is how it interacts with the False Claims Act, and why do False Claims Act cases and anti-kickback cases go hand in hand? Well, one answer is that a violation of the Anti-Kickback Statute is also a violation of the False Claims Act. And from a defense perspective, the scary thing is that the False Claims Act really weaponizes the Anti-Kickback Statute by encouraging whistleblowers to go to the government and really turn against their employers and get paid for doing so, and paid substantially, which we'll talk about in a minute. Just focusing on the law here for a second, again, not just for timing purposes, don't want to go through all these elements, But the knowingly and willfully standard here, there's a fairly high intent standard here, which from a regulated entity perspective, you would think, okay, well, that's a good thing, that there's a high intent standard. The problem is, though, there's also a what we call the one purpose standard. So yes, you have to have a high intent to violate the statute, but the statute can be violated if even just one purpose of the transaction or the conduct was to induce business kickbacks and the like. And so that means, if you're an entity in the healthcare space that's engaging with in certain transactions, and it's not really your intent or focus necessarily to generate kickbacks, after the fact, if it turns out, well, maybe one purpose of that conduct was to generate business, you have to be worried that you're going to come within the reach of the statute. There are regulatory safe harbors. There's safe harbors for things like certain types of services, certain sales of medical practices, leases of medical equipment. We won't go into all those. Healthcare regulatory lawyers, like those exemptions because they are very specific and there can be a lot of work done to try to fit healthcare clients into those exemptions. And if you fit into one, you are immune from sanction under the statute, which is obviously a good thing. Now, the tricky part is that those exemptions can be very narrow, and a lot of business conduct will not fall into those exemptions. Penalties here are severe, $25,000 per occurrence, up to 5 years in jail for criminal violations. It is both a civil and a criminal enforcement statute. And so, that's one reason why it has to be taken extremely seriously. Moving on here, here's where the real heart of this is for our discussion today. We want to talk about CIDs and really what a CID is, how to defend against a CID, and really prepare you and your clients for responding to them. Just let's talk a minute about what a CID is. A civil investigation demand is how the federal government, and specifically the Department of Justice, investigates potential violations of the False Claims Act. Congress has given the Department of Justice broad statutory authority to issue a CID whenever it believes there has been a potential False Claims Act violation. It's not limited to healthcare. You can have CIDs in other contexts. Mike was talking about the penalties a minute ago and the settlement amounts a minute ago. As we see here, there's a lot of this activity, though, is in the healthcare space. From a defense perspective, this is an incredibly powerful weapon. It basically allows the federal government to engage in civil discovery of your client without you having much recourse. There is some recourse you have, which we'll talk about, but it really gives the federal government a chance to engage in one-sided discovery, which clients understandably hate. If clients have engaged in other litigation matters, they're sort of used to discovery being a two-way street. Each side negotiates and fights over discovery and you resolve it. But here, really all the power is given to the DOJ to conduct one-sided discovery. And just let me break down the statute here for a second. We've quoted it in this slide. It's 31 U.S.C. 3733. As I say, it's whenever the government believes someone may be in possession, custody, or control or information relevant to a False Claims Act. So this is really an investigative statute. It's not. They don't have to file a case. They just have to believe that there may be information that your client is holding that might be relevant to their False Claims Act investigation. Maybe some of you on the defense side will appreciate the fishing expedition clip art here, which we have thrown into the PowerPoint. It's often how clients feel when they get these requests. The CID, can include, just like any type of discovery, it can include document requests, written interrogatories, and even demands for oral testimony. So just, let that sink in for a second. Your client can get a demand for testimony and there's not even a case going on. They can literally be deposed under oath and there's not even an active case. Now, the client is not powerless when faced with a CID. The client, if you're in a position where you receive a CID, The statute actually does give you some rights to defend against it. Under 3733B1, the statute says basically that if you receive a CID, the same standards that apply to subpoenas, or more importantly, the federal rules of civil procedure apply. And what that really means is that if the requests are overly burdensome, super broad, you can make some of the arguments that you would make in discovery, if they're not specific enough to really identify documents, if the documents don't exist, things of that nature, you can actually use those arguments as defense. And so, let's talk a little bit more how these are enforced. As the slide notes here, you have to respond to CIDs under oath. That's another very intimidating thing for a client. Not only are they engaged in one-sided discovery, but when they respond, they have to do so under oath. Now, what happens if you come to loggerheads with the government and you either think the CID is too broad or your client wants to fight it? They've hired you as a lawyer to fight it. They don't like this one-sided discovery. Well, CIDs are both judicially enforceable and challengeable in the court system. The problem here is that the CID statute has been around for decades, I think since the 80s, and the case law is just not favorable to the defense. I quoted here one of my favorite ones, this 1995 decision from the Sixth Circuit. It's an oldie but a goodie. The quote here from the circuit, characterized the CID as a means to assess quickly and at the least cost to taxpayers whether grounds exist for false claims. It's sort of like, oh yes, let's give the DOJ substantial power here to save taxpayers money. This case also has some language about it's even good for regulated entities that we can get through this discovery without having to file a case. And so the case law, it gives you a flavor for what the case law is in this realm. And I will say, when you see defendants challenging, or I should say recipients of CIDs challenging these, you don't see a lot of successes from the defense bar. You see maybe what are really just delay tactics to try to slow down the CID process, but it's hard to win a judicial challenge to a CID. Excuse me, I jumped a little too fast there. So with that statutory background, we want to talk about how to respond to a CID, but before we do that, we want to give you all a feel for the regulatory context here. And by that, I mean sort of recent trends and example cases, so that, because if you or your client gets hit with a CID, you kind of want to understand what's going on in the healthcare space to have a feel for what the OIG, DOJ is potentially going to care about in this area. And there's sort of two ways to look at this. Let me get forward here. Thank you. There's, in the literature and sort of the commentary out there in practitioners in this area, there's a lot of talk about what's hot right now. What are sort of the hot focus of OIG? Recently it was opioid related cases related to the opioid crisis. More recently, it's COVID obviously related activities, people selling COVID snake oil cures. OIG has a fraud alert right now, actually, for fake COVID testing scams, telehealth scams, billing for services not actually rendered. So, just like everything in our world this year that has changed, the medical environment has changed, and OIG is responding to that. They're saying that those are their kind of things that they're watching out for from a False Claims Act perspective. However, those are hot topics, but the bread and butter of healthcare False Claims Act cases continues to be what it has been for a long time now. And those are sort of the classic factual scenarios where you see referral payments, you see consulting that, if you look at carefully, doesn't appear to be legitimate consulting. You see cases related to device sales, and cases involving fact patterns of lavish trips, people being paid to go to great locations, ostensibly related somehow to healthcare services or conferences, but really from the government's perspective is more about rewarding people for business. We've developed this is in the materials. You guys will all get these. I'm not going to go through these, but we looked in the last couple of years at recent anti-kickback statute cases in the healthcare sector. And these are not hard to find. The government obviously publishes these. But what's remarkable about looking at some of these cases is you see kind of the same fact patterns over and over: consulting fees, referral fees. Then I want to direct your attention here to the right-hand column. The settlement amounts in these cases are just huge. They're huge because, as we all know, there's a lot of money in healthcare. But they're also huge because the statute, like Mike was talking about earlier, really provides for lots of ways to get big penalties. And that motivates the government, that motivates whistleblowers. And so, look, the dollar amounts here are big, and that should also motivate your clients when they think about the risk in this area. Look, here's another. Again, these are all just recent cases in the last couple of years. Want to not go into any detail on any one case, but just by way of example, right here in our backyard, we had a case this summer, Merit Medical, big provider here based in Utah, that just settled a case. Their admissions here as part of their settlement, the classic sort of fact pattern: consulting fees, speaker fees, trips to Paris, Hawaii, places that I would love to go to, but that in the healthcare sector are going to get you on people's radar. They paid $18 million to settle that case this summer. Olympus Corp is my favorite example in terms of recent cases because a couple of reasons. The dollar amounts are enormous. Again, you had kind of the classic fact patterns where Olympus Corp, Olympus being the same company that you and I all know of as making cameras. They also make very sophisticated medical equipment. They were giving people grants. They were having all these interrelationships with healthcare providers that really, from the government's perspective, was funneling a lot of money to people in a way that was not legitimate. In fact, this was both a civil and criminal case. As part of the resolution, Olympus agreed to a criminal deferred prosecution agreement. They paid a $623 million settlement. And to segue to what we're going to talk about for the rest of this presentation, I want you all to think about how this case came about. This case came about because of a whistleblower. I'd like you to meet the whistleblower. Here's Mr. Slowick, I think is how you say it. He was the former chief compliance officer for Olympus Corp. And while he was working at Olympus, he allegedly saw things that he thought were not in compliance. He was aware of these payments. He didn't like them. I don't know all the details about what, if anything, he tried to do internally, but when we mentioned earlier about the statute weaponizing your employees against you, this is a good example. Whatever avenues internally, whether he took advantage of them or not, ultimately what he did is he hired a plaintiff's firm. And look, Mike and I work with clients in this area. This is a common fear that you have an employee base that is encouraged to actively build a case against you while you are paying them to work for you. And Mr. Slowick walked away with a $51 million whistleblower payment in that case. Ironically, then he did some local press because he became such a well-known guy for making it so rich off the False Claims Act that he then did some local news stories where he was interviewed and he said, "Oh, it really wasn't that much because my lawyers took some of it." So it's like you can't win with the whistleblower. You can't make these guys happy. So that segues into something everyone should think about before maybe getting a CID, and I'll turn that over to Mike.
Yeah, so we in discussing how we were going to put together the presentation today, Jeff and I sort of talked about whether we wanted to include a discussion on the OIG self-disclosure process or self-disclosure protocol, as it's often referred to. And this sort of seemingly unrelated thing finds itself really inexorably tied to almost all of the CIDs that we've seen, and that is self-disclosures gone wrong or self-disclosures that could have resolved a problem before you were at the point where you were receiving a CID and other investigative materials from the government. Quickly, again, just to sort of calibrate everyone, as we know, the Office of Inspector General, it's an independent office, part of the Department of Health and Human Services. It's got offices in all of the states now. In some states, it's got multiple offices. Among the sort of the responsibilities of the OIG that are sort of relevant to our discussion today, the office is charged with resolving voluntary self-disclosures of fraudulent conduct, prosecuting administrative cases related to those disclosures or non-disclosures, in fact, excluding individuals from HHS programs and funding that would include payments for medical services, and then to negotiate and monitor corporate integrity agreements, which are often part of any kind of settlement, to make sure that problems with companies or individuals don't happen again, is sort of the ostensible purpose behind that aspect of their responsibilities. So what is the OIG self-disclosure protocol? The operative guidance for any company intending or wanting to engage in the self-disclosure protocol is a memo issued April 17, 2013. You can find this online at the OIG's website. And it sort of outlines the purpose of the protocol and how the protocol is going, is or is not handled. Generally, parties that may be subject to civil penalties can engage in self-disclosure protocol. That said, there are certain instances where the OIG does not consider the self-disclosure protocol as relevant for a couple of reasons. One, if you're looking at a situation of simple overpayment or overbilling, the perspective that the OIG has taken on that is just simply money that you owe. There's no negotiation needed to be had in that instance. That's just money that you owe and that you just need to go and pay. The OIG will not engage in self-disclosure protocols that are seeking an opinion on hypothetical behavior. Now, of course, companies aren't going to go to the Office of Inspector General and just ask hypothetically what would happen if. But what they really mean here is they are not going to engage, the OIG will not engage in the self-disclosure protocol process if you are not willing as a company, your client is not willing as a company to concede that certain things have happened. They only want to talk reality. They don't want to talk under sort of a reservation of rights situation or a prospective or to analyze prospective sort of billing patterns or processes that your company may be considering. They only want to talk about where the company is willing to concede that a mistake has been made. So the question then becomes, why would you engage in this process? The big one really is that it allows for a tolling of the statute of limitations. As anyone knows in this sphere, in sort of the key TAM, False Claims Act area, you're able to go back 6 years, and then that clock just keeps running from that 6-year period. Once you engage in the self-disclosure protocol, you get to toll that period. So that provides companies with an ability to sort of limit their damage exposure. But the trade-off there is in engaging in the self-disclosure protocol, there is an expectation that the company has already begun to take or has completed corrective action to remedy whatever the issue may have been leading to the false claims at issue that's covered by the disclosure. So the most critical upshot, I think, to the self-disclosure protocol is that really when you read the protocol and how it interacts with the statutes, you're really only talking about cases where there is a potential Stark law and anti-kickback violation that would trigger civil monetary penalties. And that's sort of a term of art in the literature, but those are the penalties that we were discussing earlier, the civil monetary penalties we were discussing earlier related to the $11,000 to $23,000 per instance, the trebling of those, as well as attorney's fees. So in deciding whether or not to engage in the self-disclosure protocol, there are some critical considerations that any company and practitioners in this area advising clients need to make. One is the behaviors at issue, is it clear-cut that there has been a violation of statutory law that would justify or compel monetary penalties? Again, they're not going to engage in hypothetical discussions of what may or may not have happened. So the process really presupposes some concession that a violation has been made. And that's a big deal, and we'll talk about that a little bit later in talking about sort of the nuts and bolts of responding to CIDs. But that's a big button to push, because at that point you are making a concession to the government that, in fact, your client has done something wrong. Second, and sort of a corollary to that, is you need to remember that the new or should have known standard that applies and I don't know if you picked up on the nuance here, but the standards are different really under the False Claims Act and the Anti-Kickback Statute, where the False Claims Act, again, is a permissive standard, right? So recklessness or deliberate ignorance is part of that knowing or should have known standard, where under the Anti-Kickback Statute, it's a little bit different. And so the consideration of what your company knew or should have known in deciding whether or not to concede that a violation has been made is really critical to the analysis. The third prong, or the third bullet point, and the other consideration that I think is a big deal here, is it's important to remember that fraud alerts that are issued in these areas, and we'll talk about one here in a minute, but the fraud alerts, while providing guidance to the OIG and the Department of Justice and U.S. Attorney's offices, those are the perspective the government has on the law and on certain behaviors. They are not binding precedent. And so there are circumstances where we've had clients where perhaps the behavior was a violation of a fraud alert or an outlined alert, but in actually reviewing the situation vis-a-vis the applicable statutes, there's room for disagreement. And so again, simply because behavior may or may not have violated a fraud alert that's been outlined prior is not the end of the consideration or the end of the discussion for the clients. There are a number of other factors to consider. And so let's see, I'll go back. Okay, so this is a picture of, and this is where like all, I wish we were all in the room and you guys could all tell me how cute my son is. But there's a picture of my son Cash, and at the time he was about 4.5, maybe almost 5. And his uncle, who will remain nameless to protect his health and safety, decided to give Cash a bunch of tattoos, temporary tattoos. And in giving those to him, we had a very long discussion with Cash that he could use them, but only if we were going to help. We didn't want him to use them all the time, because if we had family pictures or we were going to go to dinner or whatever. Well, one day I'm sitting on my couch watching college football, and in walks Cash with his winter coat on, zipped all the way up, and what is this smeared tattoo on his face. And he said, "Dad, I'm sorry, I got the tattoos. Can you help me get this off my face?" And really, he just didn't like how it looked because he had screwed it up. And I said, "Sure." I kind of gave him a talking to, but I was like, "Hey, thanks for coming and telling me. Appreciate you being honest." And then it struck me, I was like, why is he wearing his coat? And then I unzipped the coat, and I noticed that he had basically used all of his tattoos over both of his arms to essentially give himself, I don't know, some kind of biker sleeve or something. that he thought was very cool. And I use this example because, and Jeff and I can speak from experience, companies often will engage in the self-disclosure protocol to try to resolve one issue. If you don't come clean on all issues, you've basically built yourself a huge hornet's nest and a number of problems, because remember, to engage in the self-disclosure protocol, you are conceding that a violation essentially has been committed. What that does is that puts antennas up for the OIG and likely the U.S. Attorney's Office or the DOJ in that area. They're going to start looking around. And so when you file incomplete disclosures, you are setting yourself up for a world of pain for a number of reasons. And so, you know, some of just the practical considerations in making self-disclosures is you want to make sure that the disclosures that you're making really do encompass all of the potential issues involved at the company. So you want to make sure that it's an extensive disclosure, that you've done the work, that you're doing it right. You also want to consider where the disclosure falls within the general corporate structure of the entity you're dealing with. A lot of our clients will have sister companies, subsidiaries, parent companies that may or may not be directly involved in the disclosure, but the practices at those companies or in those entities may be implicated by the disclosure and vice versa. You also want to consider other tangential issues, such as whether the disclosures will touch upon prior tax filings, other sort of property investments, divestitures. All of those things come into play. One of the things that we haven't talked about a lot yet, but is worth mentioning, is these these investigations, I should say, in the False Claims Act or anti-kickback violations generally are not just focused on the company. There is, in the trends, there is a strong focus, and one that we've observed sort of as a trend, to focus also on directors and executives and owners of companies as well. And so seemingly tangential issues such as ownership of the company, transferring ownership of the company, directorships, insurance, severance packages, all of those things then can become rapidly relevant in the context of a failure to fully engage or to meaningfully engage in the self-disclosure process. And it's just important that you don't look at that a practitioner or a company doesn't look at that process as something that is, hey, we're going to go in, we're going to fill out the questionnaires, we're going to engage in discussions and provide them what they want and call it a day, because failing to really tell your story completely from the beginning raises suspicions. And once you have a suspicious department, governmental entity, it's difficult to dissuade them that you've actually done everything to sort of remedy the underlying issues. So I want to just quickly review what circumstances tend to give rise to a civil investigative demand. And this chart, I've actually seen other charts that are much more comprehensive. I've really just tried to distill down this slide to something that I think just is an easy, accessible way to understand the way that CIDs typically come about. So let's assume that in this case we have a relator that has filed a key TAM lawsuit. As we know, those complaints are filed under seal. They're not served. And so a lawsuit has been filed against your client or against your company, and you don't even know that it exists yet. So once that's filed, typically the U.S. Attorney's Office that will be involved will then request an extension of the seal. That's almost invariably granted because there's no one there to oppose it, because you don't know that it's been filed. And then the complaint simultaneously as it's filed by the plaintiff gets served on the U.S. Attorney's Office as well. For a period of time, the U.S. Attorney's Office then will sort of review the underlying facts of the complaint, do some investigation on their own to a certain extent, depending on how interested they may or may not be in the complaint, and eventually a notice of intervention or declination is filed. Still at this point, as a practitioner, you or your client do not know that you have been sued. The complaint then is sent to the civil division and the criminal division. And each of those divisions then are going to independently review and consider the underlying allegations along with their own investigation of the facts at issue and make a determination whether they want to keep the case or not. The interesting thing is a complaint, and this is what you need to be aware of, is a complaint could be filed against you or your client. The civil division could be investigating that complaint, and as part of that investigation, they serve you with a CID. So while technically you've been sued, you haven't been served. You don't know that you've been sued, but you have been, now you've been issued a CID which requires you to respond under oath to interrogatories and requests for production by the DOJ. This context is important because the assumption that you need to be making when you receive a CID is that potential exposure is not just that they're poking around and investigating, but in fact there's a lawsuit that's been filed. There's allegations that now they are seriously considering, and in fact those allegations are also sitting with the criminal division, who is discussing the case, and they're discussing the case with each other. The important sort of alert that I want to highlight in respect to CIDs today is the fraud alert that was released June 9th, 2015. This is sort of the behavior that we're seeing a lot of the litigation and settlements that Jeff highlighted earlier extending from. And these are position compensation agreements, such as medical directorships. This would also include speaking fees, those sorts of things that do not reflect fair market value are considered to be violating the FCA and the Anti-Kickback Statute. And here's where, and the reason I just wanted to highlight this one is because, one, it comes into play a lot, but it really highlights the tension between, I think, the perspective that the OIG and the DOJ has and what the market has in terms of what is fair market value for services, what do those services look like. As one of the attorneys that Jeff and I work with on a matter often says, the government doesn't believe anyone should make any money, and that's sort of the perspective that he's bringing to the table on behalf of a defendant. I'm sure that practitioners at the U.S. Attorney's Office would argue we're okay with people making money, but you have to actually earn that money. You can't be giving kickbacks. But that's the gray area, and that gray area is rife with areas that need to be explored and that need to be framed in a way that will effectively protect you and your clients.
So with that background, let's talk for a second about, you've been hit with a CID. Maybe for whatever reason you're in the gray zone. Like Mike said, there's probably a pending under seal litigation against you. We all now know that you're going to have to respond under oath to this. What do you do? And we're going to go through this pretty quickly. I want to save some time for questions and some analysis that we're going to offer some suggestions at the end. But look, you and your client have got to take this super seriously. First of all, just basic stuff, document and evidence preservation. A lot of you on the line are probably litigators or have litigation experience. Those rules apply, but even more so here because you're dealing with the government. You got to put your client in a position so that there's never any allegation that there's been obstruction or destruction of documents. What that really means is they should not only hire outside counsel, but if your client has a lot of documents or data operations, you've really got to bring in an outside forensic firm to ensure that your client doesn't, accidentally or intentionally delete information that the government wants. So beyond that, though, I mean, that's really basic. That should be something that attorneys and clients should be able to do. But there's a much more nuanced approach here to what you do when you get a CID. First of all, you got to talk to your employees. Clients hate this, understandably. Depending on the size of the company, this may be the first CID they've ever gotten, maybe not, maybe they've been through it before, but you've got to be able to talk to the key employees, explain to them what's going on, and message it in a way so that they don't think the sky is falling, but they also take it seriously. And of course, we're outside counsel. We think that attorneys are best at doing that. And it's really a bad idea for the client to handle it on its own. One reason why it's a bad idea is because the whistleblower may be in your ranks. The whistleblower may be reporting back to the government about everything you're doing to respond to the CID. And so literally, you are under the microscope and maybe in a way that you don't even realize. And so then the other thing you got to do as a client in this position is think about conducting an internal investigation. Some clients view these CIDs as like discovery. Okay, I've been through litigation before. I got to produce some documents. And look, I think our view is that you got to understand that it's more than that. It's that you're under investigation, so you have to get smart. The government has a head start on you. They've already got information from a whistleblower. They've already got information from who knows where. They've already been playing the game, and it's like the third quarter, and you need to catch up. And so you got to do an internal investigation. How big or small that is depends on a lot of factors. It's very case specific, but you got to do the basics, like define the scope of the investigation, start from the ground up, start talking to some lower level employees. There's all sorts of things that when it comes to doing an investigation that you should follow, like interview best practices that we won't go into necessarily here. But the point is, you got to treat it seriously and you got to investigate yourself. And one thing that's important is clients who get a CID, they will think that they know their own business. You as counsel, and especially outside counsel, have to tell them, no, you do not know your own business because you are biased. You have been working there for years or decades, and you think you understand how your operation works, but until you have someone come in from the outside to evaluate it from a legal perspective under the protection of privilege, you're not going to get a real assessment of what the business is doing. So you've got to really work with your client to get their head in the right place so that they allow you to do the proper investigation. That's what you do with your client. Now, what do you do with the DOJ? First of all, this seems basic, but it's important to note. The DOJ has just issued you a CID. It could be a very long, giant, set of discovery demands. First of all, you should ask for more time if you need more time. You should not be afraid to talk to DOJ about the scope of the request, with one big exception, which I'll talk about in a second. So, look, you gotta engage with them on that, but you got to do so very carefully, and you got to get smart before you really engage with the DOJ about things basic like where documents are, where the real risk is. You should also try to, emphasis on try, talk to the DOJ about the big picture. Like, hey, what's really going on here? I'm going to tell you, you may or may not get engagement on that point. If there's an under seal filing, DOJ, their standard position is probably going to be, this is an investigation. We don't know if we're going to file a case. They're going to tell you their mind's not made up, even though they may have a strong opinion. They're going to tell you their mind's not made up. And, so they're probably not going to engage. Your client's going to want you to try to settle the CID. And the tricky spot that you're in as outside counsel is you've got to, try to have discussions with the DOJ on a substantive level, get them to engage, but you got to go in there understanding that they're probably not going to tell you a lot about it because it literally is an ongoing investigation, which is what the whole statute is designed to have them do. What can you expect from the DOJ when you do engage on the CID? Well, look, they may say, oh, yeah, I'll give you an extra 2 weeks. I'll give you an extra month or whatever. And you can talk about where documents are and things of that nature. In my experience, DOJ, you'll be sitting across the table from experienced attorneys who are typically reasonable on what I call the small stuff. They're not going to they're not going to file a lawsuit to enforce the CID because you need a few extra weeks. However, there's a trap here, and there's a trap that you got to be aware of. The minute you start having discussions about, hey, let's search for records, and we want to get your opinion on this, and we've got a giant database, and we're going to run some search terms, then you're basically inviting DOJ to be your co-counsel. And you need to think carefully whether that discussion makes sense. Because once you start going down that road, you're naturally just talking to them about your own investigation of your client and what you think is out there and not out there. I mean, it's hard, for example, to talk about search terms related to a certain issue and custodians of documents without suddenly just getting into a discussion where you're admitting things about your own client to the government. So, look, one approach here that has worked for me successfully in cases is just to have as minimal contact with the government as possible, produce the documents, and be done. And that's a lot of cost and effort to your client. But, you know, sometimes there's reasons to not try to engage in negotiation discussion. Some clients want to have you talk to DOJ and try to limit the scope of the CID. Sometimes you want to minimize discussions with them, though. And then lastly, you know, think about whether you can help them. I like to say that government lawyers are people too. You know, they have feelings, and as outside counsel, you know, where we've had a lot of success is where we can convince them we know the facts and the law better. Well, maybe not the law, but at least the facts of the client better than they ever will, and that they should really listen to us about why this case should not proceed. And if you go in reasonably in that way, you know, you can have success of them listening to you. So with that, we've got just a couple minutes. Mike and I want to run through some basic takeaways. Mike, I'll give you a minute, and then I'll take a minute.
Yeah, and I'll be quick. You know, the biggest one is sort of on the preventative side. Invest in a compliance culture. I think the biggest pitfall that we see is an undervaluation and an underinvestment in this part or this aspect of an entity. The reality is a lot of companies grow, and they grow quickly, and the investment that they have in the compliance culture, in having sort of a system in place to make sure that the compliance is happening is not commensurate with the growth, and that's when you see things spin out of control. So what happens is a company all of a sudden goes from being sort of a $2 million a year company to a 10 to a 15 to a 20, and they're like, oh no, we need someone to be in charge of compliance. Well, why don't we put our HR person also in charge of compliance, for example? All you've done is set up a mailbox that's going to be full of issues that the DOJ is going to want to look at when you start producing emails and documents. So you want to make sure that you're staying a step ahead in that respect. And this is sort of, again, part of the culture. Jeff, if you want to take this part.
Well, you know what? I think we're very close to the end here. I don't want to go over. And Mike, you know, people can see the slides. Look, investing in culture just pays you back dividends. That's what Mike already talked about. You gotta be prepared to fight, but fight smart. Don't make stupid decisions and challenge the CID in a way that won't work. And manage the information that you've got, and think carefully about what disclosures you do or don't make. And I want to get here to your last quote, Mike, because I think it's a great point to end on.
Yeah, so this is sort of, we joke about this all the time, but we call it the Swanson Rule. I don't know if you guys have seen Parks and Rec, but there's a moment in the show when he's talking to Leslie about a career decision she wants to make, and he says, Leslie, never half-ass two things, full-ass one thing. And that really is the upshot of all of this. If you're responding to a CID, respond to the CID, do it fully and completely. What Jeff just said, I think, bears highlighting again. You know your client better than the DOJ ever will. So make sure you're telling the best story for them. There are opportunities in responding to a CID where you can help your client. I think a lot of us want to take a really restrictive view on we're only going to produce what we absolutely have to produce. But if there are documents, if there's information that maybe doesn't fall within the CID, but helps tell your story, helps explain to the DOJ why your client should be a target, there's nothing preventing you or precluding you from providing that information. And so it really is take a holistic, strong approach to this, and I think that you can be successful in defending your clients at what is an early stage of potentially a lengthy process.
Jason, what have the contestants won?
They have won a free box lunch for the next time we're able to do this event in person. But Jeff, Mike, great job. Thank you so much for all the effort that you put into putting on a very thorough and substantive presentation today. Thank you for your time. And I do want to let all of our attendees know, we did this in conjunction again with the criminal law, health law, and litigation section of the Utah State Bar, the health law section of the Idaho State Bar, and our Idaho health law practice, and our attorney Kevin West has a lot of attorney out of Boise defending healthcare whistleblower cases. So we offer this solution to all of our clients, irrespective of region. Thanks to all of you who took time out of your busy schedule to join us today. For those of you that perhaps joined a little bit late, I do want to let you know that this presentation was recorded. You will be receiving a link, or an email rather, from us tomorrow with a link to today's recording, a PDF document containing today's slide deck, and also a request for you to provide us with your bar number. Please do so, and we will take care of your CLE credit and submit that on to your respective bars on your behalf. And with that, I'll say we wish you all the very best. Stay healthy, and thanks again for participating in today's CLE.
Thanks, everyone.
Thank you.